Welcome back to CTEducation, your home for education in all forms, shapes, and sizes. Today we are diving back into the complex world of trademark law, specifically focusing on what happens after a trademark application is filed. We'll be focusing on opposition, rectification, and the concept of honest concurrent use. Now let's start with trademark opposition. A trademark application should only be registered if it is distinctive and can function as a trademark. Additionally, no third-party rights in a singular trademark should be impinged upon by the new trademark's use and registration. Once an application for a new trademark has been accepted by the registrar and advertised in the patent journal, any third party who wishes to oppose the new registration may do so. When a new trademark that is still in the registration process is opposed, the onus is on the person who applies for its registration. They must prove that the trademark is distinctive and can function as a trademark. They must also prove that no third-party rights would be impinged by the new trademark. This differs from a case where a trademark has already been registered and a person wants to cancel it. In that situation, the onus is on the applicant for cancellation to prove the necessary conditions. There are several grounds for opposition. These include a lack of intrinsic registrability and the mark being prohibited. An application can also be opposed if it is not in good faith or it contravenes third-party rights. Now, regarding third-party rights, the applied for trademark can be opposed if it is similar to a registered trademark or a mark for which an earlier application was filed. Opposition is also possible if the new mark is similar to a mark that has been used by a third party for some time, even if it is not registered. Another ground is if the trademark is similar to a well-known international trademark, regardless of its registration status. The dilution of a well-known registered trademark is also a valid ground for opposition. The procedure for opposition follows a specific timeline. First, the opponent files a notice of opposition, which is from TM30, along with a founding affidavit. The trademark applicant then has 1 month to file a notice of intention to defend, using Form TM4. Following that, the applicant files an answering affidavit within 1 month. The opponent then has 2 months to file a replying affidavit. Finally, the matter is set down for hearing before the Registrar of Trademarks. Now, let's look at trademark rectification. This process is used when a trademark entry was a wrong entry or wrongly remains on the trademark register. An interested party can apply for rectification if the owner or licensee failed to comply with conditions or to cancel a trademark for non-use. An interested party is someone who has a substantial interest in the mark being removed, or a genuine and legitimate competitive interest in the trade to which the mark relates. This can be a person who genuinely intends to trade in that sector, an applicant whose own registration is blocked, or a competitor whose business field is narrowed by the offending mark. Now, the grounds of rectification include an entry that was not inserted, or was wrongly made, or wrongly remains, or has an error or defect in the register. These grounds are used to cancel a trademark that should not have been registered in the first place because it offends against any of the conditions in Section 10. One of the main grounds of rectification is cancellation for non-use. This can happen if the trademark was registered without bona fide intention to use it, or if it has not been used for a period of 5 years since the date of registration. It can also be cancelled if the company that owns it was dissolved, while the person who owns it has passed away in the last 2 years and no application for assignment was made. Finally, let's look at honest concurrent use. This scenario often arises when a party has been trading for a number of years under a brand, only to find during a trademark search that a similar mark is already registered. In this case, the trademark with the earlier application date should be accepted while the latter is provisionally refused. In such a situation, this is where Section 14 comes in, allowing an applicant to file a trademark on the basis of honest concurrent use. This section allows a trademark to be registered even if it offends against certain sections of the law that would ordinarily prevent its registration. The applicant must prove that the adoption of the trademark was honest and concurrent. The elements that need to be proven include the degree of confusion likely, the honest nature of the choice, the extent of the use, whether actual confusion has occurred, and the nature of the respective trades. Now, while an application for honest concurrent use is more expensive than an ordinary one, it is an effective way of registering trademarks that would otherwise not be capable of registration. We at CTEducation believe that knowledge is power, especially in the legal landscape. By understanding these procedures, you are better equipped to protect your intellectual property or challenge potential infringements. Thank you for joining us today. If you found today's video helpful, don't forget to like, share, and subscribe.